Representative Grossel, welcome. You may.
Thank you, Mr. Chair and Committee. I'll be presenting House File 2904 today. It is relating to public safety, increasing penalties for child pornography offenses, creating a mandatory minimum sentence, directing sentencing guidelines commission to modify the sex offender grid, and amending some statutes in there as well. And I was also going to make a verbal amendment, if I may.
And that would be?
That would be on page 2, line 2.2. Yeah, 2.20. It'll be 50 instead of 50. It'll be 25.
First. Is that the only oral amendment that you have?
Yes, sir.
Is there any questions on the oral amendment? Representative Hillstrom, do you have any questions on the oral amendment?
Mr. Chair, not on the oral amendment, but why don't we take that and then I'll ask another question about that.
All those in favor of the oral amendment signify by saying aye. Aye. Opposed? Well, you go ahead with the presentation of the bill.
Thank you, Mr. Chair and Committee. I just wanted to start out with a quick video clip.
Looking at child pornography, does it give you a sexual gratification?
It did a while ago.
The voice on the recordings, never heard publicly until now, is Jacob Kim. It was 2012 as investigators interrogated him here in his living room about videos of child sexual abuse.
Did you share any of the clips with anybody, send anybody?
I probably did.
Okay, did you receive any from other people?
Yeah.
Court records detail graphic videos found on his computer, including of children being raped. Very young children.
How old do you think they are, roughly?
I have no idea.
You guess 5, 6, 7?
I suppose.
Is there an age that you consider too young? It just doesn't do anything for you?
Probably under 6.
The admitted pedophile was convicted in 2013 of possession of child pornography and sentenced to 120 days in the local jail and probation. Not a single day in state prison. But now, the newly released recordings raise the question, did those old interviews foreshadow what was about to happen while he was still out on probation?
Authorities are searching for a missing 5-year-old girl.
The search for the missing girl was launched when her babysitter, Melissa Norby, was found dead, arms bound in her burned-out home. Attention soon focused on Kin, who was dating the babysitter. Investigators found text messages indicating he plotted to acquire the girl for the purpose of sexually assaulting her. They tracked his cell phone signal to a remote location where they found the girl, assaulted and bound in duct tape.
She's safe and alive.
So far, no charges have been filed in the babysitter's death, but Kin is awaiting trial accused of kidnapping and sexual assault. Something the 2012 tapes suggest he may have been fantasizing about years earlier.
You know that these children that you watched in these clips were, say, under the age of 10? Yes.
In fact, at one point, Kin claimed the reason he watched the child rape videos was to relieve the urge to act out himself.
I used to look at it, I guess, as to relieve the want to do.
Sentences like the original one that Ken received, a few months in a local jail as opposed to state prison, are among the reasons some state lawmakers want to toughen Minnesota's child pornography and other sex crimes laws, which critics describe as among the weakest in the entire country.
Here in Minnesota, we have some of the weakest.
We do, as far as policies, with our Sentencing Guidelines Commission very often calls for probation for many of these crimes. We actually found when we looked at even child rape and sex assaults.
Thank you, Mr. Chair. And with that video, a tragedy came later with that murder and the eventual rape and kidnapping of that child. Everybody's pretty familiar with that, with the outcome. The person was charged and convicted and imprisoned. But with that being said, I look at the child pornography statute as it sits. We have many examples of defendants not willing to cooperate with other crimes because there's child pornography. If they're hooked up on a child pornography charge, they have to be threatened with federal charges before there's cooperation, or before anything, or before there's really any prison time. I'll use Jacob Wetterling's abductor as an example. They got him on pornography charges later in years. And until he was threatened with the federal child pornography charges, he would not cooperate as to where Jacob's body was. That's one example. I have testifiers here that will add more to what I'm seeing as far as being a very weak statute in our criminal law. So with that being said, I'll introduce my testifier here, Nicole McKinnon, and her daughter Maya.
Okay, before we get to the testimony, I want to double check on line 4.2. Do you need an oral amendment to also change that to 25 years?
Oh, yes, sir.
Okay, with that, the chair moves an oral amendment on line 4.2 after lease, change 50 to 25. Any questions? All those in favor of the oral amendment say aye. Aye. Opposed? The amendment is approved. Go ahead with your testimony. If you could introduce yourself and proceed.
My name is Nicole McKinnon, and this is my daughter Maya. I told her what I was coming here to do today, and she thought it was important to be here with me, because this is really important to her too. I was asked to come here today by Mr. Grossel to talk to you about my experience with the current laws and sentencing guidelines for sexual predators and child pornography offenders. This is not an easy thing for me to do, and is certainly not easy for my 14-year-old daughter. Being here today is not within my comfort zone by any means, but we have been through hell in the past year, and our story is important for you to hear. Our pain and frustrations come not only from the situation we found ourselves in, but also the laws that are in place which we feel failed us as victims. Victims of sexual predators feel a lot of shame and embarrassment. They also carry a lot of guilt and responsibility for what happened to them. The sentencing guidelines, as they are now, help to promote the feelings of guilt within the victims to the point where they think maybe they should be punished as well. And many of them punish themselves for the rest of their lives. During the sentencing hearing in the case I'm about to discuss, we heard story after story of young girls cutting themselves and attempting suicide after their abuse finally ended. Because of that, the punishment for this type of crime needs to be much more severe. We need to show these kids, like my daughter, that this behavior is not tolerated. The violation of children in Minnesota can no longer be a slap on the wrist offense, and the kids should not feel like they need to share the blame and punish themselves. Just over a year ago, my daughter was a normal 13-year-old middle school teenager. Actually, she's a pretty extraordinary kid in my eyes, but I might be a little biased. In March of 2017, her biggest worry in life was the fact that she was getting braces put on her teeth in a few weeks, and maybe a little friend or boy drama here or there. She was enjoying school and enjoying life. She was into snowboarding and skateboarding and was a member of the middle school swim team. The year before, she'd been voted class president, and through student council had formed some pretty close relationships with teachers and administrators at the school. Maya's teachers really liked her, mostly because she was so helpful and thoughtful. She would constantly beg me in the car on the way to school to stop and get a donut for Mr. Whoever because he looked sad yesterday, or ask if we could get coffee for Mrs. Whoever because her pet turtle died or something. She had this level of empathy and compassion that's rare in middle school kids these days. Her teachers noticed this and even seemed to treat her a little bit differently from other students. She had privileges awarded to her that other students didn't have. She was allowed to hang out in certain teachers' classrooms in the morning before school and even charge her cell phone in the assistant principal's office during the day and stop in between classes to check messages or to send a quick text. The progression of this was slow and seemed so natural that it didn't raise red flags like I really wish it had. I was simply proud of my daughter who was flourishing in school, and I was excited to see that so many other people thought she was as amazing as I think she is. There are so many things we know we need to protect our children from. I thought I'd done a really good job keeping my children safe. None of them had even broken a bone or had anything particularly scary happen to them. I was fine with letting my kids feel angry or disappointed if I had to tell them no, they couldn't do something because it was unsafe. When I drop them off at school, I worry about all sorts of things. Bullies, boys acting inappropriately, is their homework getting done, the big math test coming up, the gray stuff my daughter said she had for lunch yesterday. But I never really thought to worry about keeping my kids safe from the people I trusted to educate them. In late March of 2017, I was hit with a massive dose of reality, which felt more like a baseball bat to the head. Someone had been sexually grooming my daughter via social media. He told her he was a middle school boy from Duluth who had recently lost his mother and was dealing with all sorts of issues at home with his father. He felt alone and afraid. My daughter, being the compassionate person she is, felt terrible for this boy she didn't even know. She wanted to help him and do anything she could to make his life better. They spoke often, as teenagers do, via Facebook and Snapchat, and they became close. He slowly pushed for the communication to turn sexual in nature as he showered her with compliments and made her feel she was really helping him get through this difficult time in his life. He persuaded her to send nude photographs to him. Investigators from the sheriff's office came to my office one morning to let me know what was happening and to ask permission to interview my daughter at school because the boy from Duluth was not who he said he was. He was a grown man, and Maya was not the only victim. I did everything they asked. I allowed them to interview Maya. I allowed them into my home to photograph my daughter's bedroom and her bathroom. I was in complete shock. The anger and disbelief I felt was unimaginable. Some man was grooming and using my daughter for his own sick pleasure. There were nude pictures of my little girl being used for disgusting purposes. The investigators couldn't tell me who the man was until they had him in custody. It took 2 days for that to happen. In the meantime, I brought Maya to church and we talked with our pastor about what had happened. We set up a plan and worked through this and the relearning of appropriate behavior. I brought her to a counselor. I'm also not proud to say I yelled at her. I was angry and disappointed that my kid had been so stupid. I was angry at myself for not being more like the helicopter parents I ignorantly prided myself on not being like. I also made some phone calls to the school to start building a support system for Maya. I had wanted to let the people Maya trusted most in the school know that something disturbing had happened and that Maya might need some special considerations over the next few days. I called the assistant principal. When he didn't answer, I tried his cell phone. I had his personal phone number because he was so close with Maya and had helped her through many issues in the past and would reach out to me after. I was disappointed when he didn't answer his cell either. The next day, the investigator's black SUV rolled into my driveway, and I felt the smallest bit of relief. I hoped this meant the pervert was in custody and we could move on, a valuable life lesson learned. Unfortunately, what he was about to tell us ended up being more devastating than we ever could have imagined. The assistant principal at the Bemidji Middle School had been arrested and charged as a sexual predator, and he had already confessed. The assistant principal had been engaging in disturbing sexual conversations with my little girl. Conversations that the investigator said sickened him, a seasoned detective. and he hoped I never had to learn the full extent of it. The assistant principal had nude photos of my child, which he used for his own sexual pleasure. He told me this, and my heart dropped, knowing I now had to tell Maya. I called her into the room and I hugged her. I told her everything was going to be okay and that I was here for her no matter what. Then the investigator and I told her the truth about the situation together. It took her a few minutes to fully understand what we were saying. The impossibility of it was almost comical to her at first. But it didn't take long for her world to come crashing down. The color drained from her face and she started to sob. The investigator, a big bear of a man, had to excuse himself as his eyes filled with tears. As he was walking to the door, with a broken voice, he managed to explain that he had a daughter too, and he was going to make certain that justice would be served. He left and my 3 other children came into the room. We all held each other and cried for hours. I don't think any of us got much sleep that night. The next day, I was on a mission. I marched into the school and demanded to speak with the head principal. I was angry, probably looked a little scary, and I don't think anyone at the school dared to tell me no at that point. I had questions that I wanted answered. I needed a plan for Maya's future, and I needed it now. After that lengthy meeting at the school, I headed to the district offices to speak with the head of human resources. I again showed up unannounced and demanded a meeting, which I was given immediately. The whole angry mother on a mission thing is pretty effective. At this meeting, I was told that the assistant principal was still employed. He was put on administrative leave and would continue to receive his pay unless a conviction was made. I left that meeting even more fired up. By now, it was time to head over to the courthouse for the arraignment, which I was not going to miss. I needed to look that man in the eyes. I sat in the front row. I must have still had that angry, scary mother appearance because they posted 2 bailiffs on either side of me during the hearing, probably for good reason. But the reason I'm here today starts at this point in my story. Because this man was a first-time offender, he was given the option of posting a low bail amount with conditions attached, such as no access to the internet and no contact with children. Or he could post a much higher bail with no conditions at all. He ended up posting the higher bail and was released, just like that, able to return to his family, able to do anything he wanted. This man, who had just confessed to preying on kids, was free to go sit at the playground on his laptop if he wanted to. He was ultimately given the opportunity to buy himself access to children. I was furious that this was allowed. But unfortunately, it was actually about to get a whole lot worse. The prosecuting attorney invited me up to his office after the arraignment to talk about what would happen next. When we arrived in his office, he explained to me what just happened in court was completely normal, pretty much exactly what he expected to happen. Not surprisingly, this didn't calm me down much. Someone known to violate children, a dangerous predator, was free to go with no conditions, and this was all perfectly normal. I learned he could walk up to my front door if he wanted to. I was terrified for my family. I started to think of people we could stay with, places we could hide. It was beginning to become obvious that the legal system was not interested in keeping us safe. The prosecutor then put a sex offender sentencing guideline grid in front of me. This was something I had never seen before, didn't even know such a thing existed. He explained that the principal, with his new high-dollar attorney, was a squeaky clean, highly educated first-time offender, which meant he came in with 0 criminal points. He also explained that the severity of what they knew about the crimes up to this point were considered a very low-level G. I believe there were only 2 or 3 charges at this point, which meant the sentencing guidelines suggested a presumptive stayed sentence, no jail time, and no registration on the sex offender list. My daughter's abuser was labeled a first-time offender by the court system. Maybe technically that's true, but the benefits given to first-time offenders are huge, and he had confessed to preying on innocent children for his own sexual satisfaction for at least 3 years. He took what he knew about these kids by getting to know them at school, his place of employment, and use his position of authority to groom them and use them for sexual purposes. But he's considered a first-time offender. Does that seem right to you? Does he really deserve a break because he was smart enough to figure out how to carry on this disgusting scheme for a really long time without being caught? This left me with horrible thoughts that kept me up at night. Should I hope that more kids were hurt by this man so he would receive more criminal points? What a sick thought. I hated myself for thinking that way. But it felt as though my daughter's pain, the abuse she suffered, didn't mean anything. The sentencing grid was like a sick board game, and we were losing. How would I explain this to my daughter? What happened to you is really bad, but the court system doesn't think so. So this horrible person isn't going to have consequences. Do you understand how that makes a kid feel? It makes them feel like blame and consequences are due somewhere. A terrible crime was committed, and the offender isn't receiving consequences, then the victims must hold some responsibility themselves. I'm convinced that if my daughter's abuser had been dealt with appropriately, she would have been spared a lot of unnecessary pain. She would have fully realized the severity of what happened and let the blame rest on the principal himself. She would have walked away with a life lesson instead of carrying around baggage filled with guilt and responsibility. At the end of the investigation, it was found that over 55 children had been victims of the assistant principal at the middle school. 55 children and hundreds of family members' lives changed by this sick man. I thought surely this would be enough to put him away and throw away the key. But again, I was very wrong, and this was not the case. Because of the definition of child pornography, as defined in Minnesota, many of the pictures the principal was in possession of did not constitute child pornography. Let me make sure I'm clear here. A man in position of authority at a middle school has nude pictures on his computer of the very children he sees and mentors every day, and only a few are legally considered child pornography. Pardon my frankness here, but why? What are you people doing? Why is the law like this? It is so wrong. How is this protecting our children in Minnesota? Take a minute and think about your own children, your grandchildren, your nieces and nephews. I didn't put much thought into this until it happened to my family, so I understand others not giving it the complete attention it deserves, but I'm asking you to do that now. Do it before it touches your loved ones. Fix these problems and make the changes that need to be made to these laws. Our story has an ending that I can live with, but only because the federal government agreed to take over the case and was able to sentence him based on federal guidelines. This man was looking at a maximum of only a few years in jail before the assistant U.S. attorney took over and saved the day. She is a hero in my eyes. I am so relieved to be able to tell you that the man who hurt my child was sentenced to 25 years in federal prison for what he did, plus lifetime supervision after he's released. He will be registered as a federal sex offender, and a long list of measures will be taken to prevent him from ever hurting anyone else. But this doesn't change the fact that we were first failed by Minnesota. More children are failed by Minnesota every day the laws stay as they are. Minnesota wanted to send this disgusting sexual predator back to his comfortable life with barely a slap on the wrist. The federal government understands the severity of this problem and sentences these predators appropriately. Minnesota needs to do the same. We need to fix the sentencing guidelines because they are outdated and they do not serve justice. They do not protect the children of Minnesota, and they cause more harm than good. Mr. Grossel has a good start here with his bill, and I'm so thankful to him for feeling personally responsible for protecting Minnesota's children. I hope you all feel the same way, as you should as elected officials. This bill is a good start, but there's still more that can be done. If you're sitting here worrying about this bill going too far, as I've heard some people feel, just ask yourself how far you would go to protect my daughter sitting here today. How far would you go to protect the children in your own lives? This bill does not go too far. Please, let's give the sick predators in our state one more reason to leave our children alone. This is our story, our extremely painful experience, And now I can pray and trust that you'll do your job and do the right thing. Thank you.
Thank you for giving us your experience, unfortunate experience that you went through. Is there any questions for this witness or testifier, I should say? Next, we have Drew Evans from the Director or Superintendent of the BCA. Good morning, Superintendent.
Good morning, Mr. Chair and members. I'll be very brief as I understand you're under a tight time frame here. Representative Grossel just asked me to share a little bit about the issue of child pornography from our perspective in the state of Minnesota. The Minnesota Bureau of Criminal Apprehension has 18 agents dedicated to this type of work, along with human trafficking and predatory offender investigations. We're the ICAC commander for the Internet Crimes Against Children Task Force, which operates across the state of Minnesota, which has approximately 100 affiliates, other law enforcement agencies that are working on this very important work. Minnesota last year had 2,148 cyber tips of suspected child pornography or online exploitation of children across the state. What we talk about when we talk about child pornography and the concern that we have with it is that when an image is shared and somebody uses that for sexual gratification, that child who is victimized and then recorded and then disseminated is re-victimized every single time that image is viewed and re-disseminated across the state. And so we treat this as a very serious crime that is investigated thoroughly by our agents and task force affiliates across the state of Minnesota. We continue to see the number of tips into the state of Minnesota rise year after year, and this is a problem that we take very seriously. And with that, I will let you move to your next testifiers unless there's any questions from members.
Any questions from the members? Okay. Caroline Palmer.
Thank you, Mr. Chair, members of the committee. My name is Caroline Palmer, Public and Legal Affairs Manager for the Minnesota Coalition Against Sexual Assault. I will just be brief as well, and just wanted to be here to express our support and to thank Representative Grossel for all of his efforts on these issues. I really think that the testimony that you heard from the survivor and her family pretty much said it all from what we would tell you, and so I want to thank them for coming forward and sharing their story. We recognize the challenges that exist with our state laws and how federal law sometimes has to come in and take care of matters. So we appreciate all of your attention to this issue. We also want to make sure that this committee, and I know we'll think about this, is where we can also make sure that we're providing appropriate and good treatment opportunities for offenders as we're looking at the penalties in the system too. So thank you very much.
Thank you. Ryan Elson. Welcome to the committee. Please state your name for the record and proceed.
Thank you, Chair. My name is Ryan Else, E-L-S-E, and I'm with the Minnesota Association of Criminal Defense Lawyers. I'm not here to advocate on behalf of sex offenders. I'm here to advocate on behalf of the discretion of court professionals in the criminal justice system. Judges, prosecutors, and defense attorneys are in a much better position to judge case-by-case basis what the appropriate sentence is for a person. And we should leave that discretion open to them. For example, with the conditional release period, giving them the tool of up to 25 years would be much preferable to a mandatory 25 years. And a mandatory minimum jail sentence takes away discretion from judges that get to see these cases, get to know who the offender is, and can make a decision based on the circumstances of the offense. And since I know we're tight on time, I'll keep it at that. But thank you.
Any questions from members? Anyone from the audience wish to testify on this bill?
Good afternoon, Mr. Chair. My name is Teresa Paulson. I'm an attorney with Civil Society. Civil Society is a nonprofit organization out of St. Paul, Minnesota, that represents victims of sexual assault, child pornography and human trafficking in civil proceedings with navigating the governmental resources available. Civil society supports a mandatory minimum sentence. In this matter, the mandatory minimum is 6 months for a first-time offense. At this point, an offender must have 12 prior criminal points. Under the Minnesota sentencing guidelines, a criminal point, if you're only using misdemeanors, it takes 3 misdemeanors to get 1 criminal point. I believe it takes, and I'm missing a couple of them in the back of my head for the gross misdemeanors and felonies, but typically speaking, people who are being caught with child pornography are going under the radar. It is not unusual for what happened in Bemidji is not unusual. This legislature, the legislature a couple years ago, went through the process of enacting the solicitation of minors using electronic communications statutes for the purposes of addressing how grooming is going under the radar. And child pornography is another element of that grooming. It is part of the process that sexual predators use on children to get them to lower their inhibitions for sexual conduct. That's the point of grooming. A mandatory minimum sentence is required when courts and the Sentencing Commission are not putting in the thoughtfulness towards the age of the victim. Under the current guidelines, a prosecutor must argue upward for any prison time to be served or any jail time in the local workhouse facility. 2 of the factors that a prosecutor must prove to the judge is that the particular vulnerability of the victim and the egregiousness of the offense. In child pornography, it is the exception when an offense is not egregious. It is the exception when a victim is not particularly vulnerable, because by its very act, the way that child pornography is created, it is to create an egregious act against a particularly vulnerable child. And so when our mandatory minimums do not reflect the vulnerability of the victims and the egregiousness of the offense that other people then acquire with no regard for the harm that that child went through in the creation of the image, we're not meeting our societal standard. This is about community justice. It's about our children in our community, children who will become adults and hopefully great members of our society. And acknowledging when an egregious harm has been committed against them, and making sure that the Sentencing Guidelines Commission and judges are holding offenders responsible for at least 6 months. And I'll yield for questions if anyone wants.
Any questions? Any discussion? Representative Hilstrom.
Thank you, Mr. Chair. And members, this is not a new issue here. A few years ago, and maybe even last year, we've heard bills, and I've carried bills changing the definition of child pornography. We still don't have it quite right. And so while this does speak to one piece, I wanted to validate the testimony that came from the mother who testified. The interpretation is that mere nakedness is not child pornography. And so if someone takes pictures of children, for example, in a locker room, and the children are naked, even if they weren't, if they didn't know the pictures were being taken of them, a judge has actually ruled here in Minnesota that that is not possession of child pornography. And so we have a lot of work to do with this statute, and I'll leave it at that.
And with that, we'll lay this bill over for possible inclusion.